Good evening, everyone, and welcome to tonight's, the February 23rd City Council meeting. If you are able to, I would welcome you to stand with me for the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good evening, everyone, and we'll get ready to start tonight's council meeting. Our first item up is citizens' concerns about items not on tonight's agenda. This is an opportunity for citizens to address the mayor and city council on the record in the open public meeting. No immediate action will be taken on these issues in the interest of fair and transparent city government. All issues will be investigated, researched, or addressed as necessary with the consensus of the city council placed on a future agenda. This is for items not on tonight's agenda. You will have, if you wish to speak, we'll ask you for your name and your address, and you'll have 3 minutes. Is there anyone who wishes to address the city council? Go ahead and push that button in the front there, at the very base of it. It should go green. There you go.
Okay. Hi, my name is Bobby Hodge Jr. I am at 111 East Comp Avenue, apartment 410 here in Bonner Springs. I am here to address some of the vandalism that has been occurring over time. So a while back, you know how the waterway that was improved right by Bluegrass and Morris, right there, that construction that was done right there. Well, some people have been tagging that area, and I've been seeing that around town. So if you're on West 2nd Street, past the elementary school before you get to 10-2, there's those stone ways right there that sit on the sides. People keep tagging that every single time. And it's really obnoxious because that's not what our community is about. And I feel that's not right to do that to something, because if you're gonna tag something of your own that belongs to you, but don't tag something that isn't yours. That's my thought.
Thank you, Mr. Hodges. Is our police department, I assume, are we aware of, we've been having some complaints, so you're aware of the issue we've been having with graffiti or not? We're not aware of any? Okay, so we will make sure the police department goes out, maybe looks at those areas, and if you get a chance, you might inform them and explain to them the areas where you've seen some of that graffiti at.
Yeah, I'm going to take pictures of the areas, and I'm going to get that taken care of.
Okay, thank you, Mr. Hodges. Hodge, I'm sorry. Well, I thought maybe there was 2 of you there, so I was going to go plural. Is there anyone else who wishes to address the city council? Come on up here. Go ahead. On the very base there, there's a button to push.
Green light, there we go. Good evening. My name is Greg Gibson. I reside at 13116 Heritage Drive in the Deerfield Village subdivision. Before I begin my prepared remarks, I will say that these remarks do not pertain to anything on tonight's agenda. When I was preparing to attend the January 20 Planning Commission meeting, I was reviewing their agenda packet for that meeting. And in reading the November 18 Planning Commission minutes, I read that Paul Zepps had asked about Old Dominion trucks using the K7 and Kansas Avenue intersection, turning off onto Kansas Avenue and then turning at the South 129th Street to get to their terminal. Before the January 20 meeting began, I asked Mr. Zepps if he had received any response regarding his query. He indicated that apparently at some point in the Old Dominion approval process, and with whatever documents or agreements or arrangements that were made between parties, there was to be an enforceable agreement regarding their semi-truck access. but that enforcement verbiage never made it to the signed agreement. Fast forward back to current time, obviously Mr. Zepp saw this as an ongoing issue since he brought it up as an inquiry at the Planning Commission meeting several months ago. Prior to and continuing after his query in November, I have witnessed semi-trucks continuing to use Kansas Avenue and 129th Street, both coming and going. A few weeks ago, I was leaving Walgreens, and I was at the stop sign at 129th in Kansas. There were a couple of cars in the left turn lane at that stop sign wanting to turn left or east onto Kansas Avenue. And sure enough, here comes an Old Dominion truck, and he began to turn onto 129th. And oops, as wide as he tries to make that turn, he's not going to make it. So those cars at the stop sign had to back up. Fortunately, there were no collisions, but it's just a matter of time. Besides the safety concern, what is that constant heavy truck traffic doing to the wear and tear on those city streets? A nice wide street at Speaker Road was built almost exclusively for the use of those semis, whether they are heading to Old Dominion or now to the new Quick Trip for a fill-up. I would encourage the city to find a way to fix this. Perhaps posting signs on 129th at the south side of the Quick Trip entrance and also at the 129th and Kansas Avenue intersection that say no through truck traffic. It appears that there is already a municipal code in place, Chapter 15, Section 15-202, that places load restrictions upon vehicles using city streets with a handful of street exceptions. 129th Street is not one of those streets listed as an exception. I hope we can make some positive changes regarding this situation. Thank you.
Thank you, Mr. Gibson. I will turn that over to staff to do a little research on that. I do know we have in the past have had discussions with Old Dominion, and they are fully aware that we prefer that they use Speaker Road.
Yeah.
And we try to reiterate to them that they need to let their drivers know to not utilize Kansas Avenue. But I will turn that over to staff to do that additional research.
Yeah, it sounds like through the statutes, through the city regs, we have an enforceable way to prevent that. So maybe we can. Hopefully, we'll come up with some solution.
Thank you, Mr. Gibson.
Thank you, sir.
Is there anyone else who wishes to speak to the council? Seeing no one else, we will then go ahead and move on with before we go into the consent agenda, we will have a presentation this evening by the Wyandotte County District Attorney, Mark Dupree. Mr. Dupree.
Thank you, Mr. Mayor, and thank you, council, for allowing me to come and present before you tonight. It is a pleasure always to be in Bonner Springs. I don't take it lightly. I think this is year 9 for me since being in office, and first thing I did after winning was sit down with then mayor as well as the then chief of police, and I was told directly, and I picked this up after a while, that you don't ask people in Wyandotte County, I don't care where, what's on their mind unless you're ready to receive it. And the first thing that was on both of their minds is that we don't feel that Wyandotte County DA's office represents us. And in no uncertain words, your chief at the time was a little bit more candid than the mayor. He was a little bit nicer. And the chief said, you do not come and talk to us. You don't come and tell us what's going on. And you sure in the heck doesn't come and party with us. I said, well, I don't party, I'm a preacher. They say, no, I know partying preachers. And so since then, I have come out here, and every year we present to you all. I have met all of your chiefs, and I have offered for each of you to come to my office and sit down specifically with me if you want to learn more about what we do. I have had a chance to party a little bit with Bonner. You guys throw a pretty good one. And so with that, I think this is minus the 3 COVID years, this would put me at about 5 or 6 of these presentations. So it's my hope that same sentiment is no longer here. However, I will tell you, Saturday night I received an email from the chief with a litany of questions that he wanted me to answer for tonight. And so what I'm going to do is I took all of the questions that I had the ability to after my Sunday sermon, and I put it all in writing. So tonight I'm going to actually read a speech, and I'm not used to doing that, but I tried to get as much as I could in there. And I would also say that if you guys desire any conversation with me, please just reach out. And again, you're always welcome to come to my office. You don't have to wait till I show up during this time, and we can have a conversation. But having said that, I'll jump right into this. Now, you should have a short little PowerPoint in front of you. It's really not a whole PowerPoint. It's just to give you the statutory understanding of the DA's office, which states KSA 22A101. The DA's office is created in the 29th Judicial District in Wyandotte County, and the statute reads, and I quote, "Said district attorney is hereby declared to be an executive officer of the judicial district in which he is elected, with said office constituting a separate entity within said district for administrative purposes, and in no event shall the district attorney be deemed an officer of any county. The district attorney is technically a state employee funded by the county in which they operate." I say that to make sure that we're all under the same understanding that this office is not a part of the unified government, and it's not a part of Edwardsville City Council, and it's not a part of Bonner Springs. It is a part of the state of Kansas, but funded by the county. So I wanted to make sure that that's clear. The rest of what you have here is affidavits and warrants, and I'll touch that just a little bit to give clarity, but I thought it was important for you to see it when I talk about it as it comes down to cases. Vast majority of those questions dealt with how cases are brought in this office, and so I'm going to read the breakdown of how a case is brought. This should last about 6 minutes, and then I'll entertain questions, but I'm going to just read through this thing here, okay? There is the investigation done by your local police department or the sheriff's department, the state or federal agency. The incident is documented with written reports, written statements, video, photographs, and the collection of physical evidence. If law enforcement has probable cause to believe that a crime has been committed, they can arrest the suspect and take them into custody or forward their reports to the district attorney to charge later. This is where my office comes into play. Investigators or their detectives submit their reports to the prosecutors for review. We review them and decide what, if any, criminal charges can be filed. The prosecutor must believe beyond a reasonable doubt that the evidence is solid enough to secure a guilty verdict from a jury. If that standard is not reached, the charges cannot be filed at that time. It's important to note the difference between the standard to arrest and the standard to charge. To arrest is significantly lower than that of beyond a reasonable doubt. To arrest is the standard that police has to utilize to arrest. However, beyond a reasonable doubt is the highest legal standard in the United States, and it is a high bar to attain, as it should be when considering charging someone with a crime that may take their liberty away. Notwithstanding, law enforcement and the community do an amazing job with getting the evidence that is necessary to reach that standard, which allows this office to file charges. After the investigation yields charges, the next step is an initial hearing or first appearance. This first appearance hearing is where the defendant, who is the accused, is informed of the charges by the judge. and the defendant can choose to hire an attorney or have one appointed to represent them. They then have their case set on the criminal docket, which is when the court hears multiple cases at the same time, after which the accused will decide whether they want to set the case for a plea court date or set for a preliminary hearing. Now, we're on the discovery process once the case is filed. Once we've found that there is enough evidence to move forward, we're at the point where the defense attorney and the prosecution find out about each other's case. The state is required by statute, by law, and by case law to turn over the reports, the photos, the videos, and any other evidence that proves the guilt or the innocence of the defendant. We're now having to provide all of this information to the defense lawyer at that specific stage of the case. After which, then we move into possible plea negotiations. Plea negotiation is a phase which is where conversations or mediation begins to determine if an agreement between the defendant and the prosecution to resolve the criminal case without going to trial can be reached. Plea negotiations can take place anytime after the defendant has been charged, even mid-trial. In America, the data shows that over 85% of criminal cases plead out. Likewise, plea negotiations happen in the majority of the cases here in Wyandotte County as well. The prosecutor must balance a variety of factors when considering a plea offer: the strength of the evidence, the willingness of the witnesses to testify, the amount of time that has elapsed from the actual crime and the possible trial, the criminal history of the defendant, the safety of the community from the defendant, the desire of the victim and the victim's family, and lastly, the amount of county resources and funds that it would take to go to trial. It is with all of that in mind that the prosecutor must determine what a fair and just outcome is, in addition to protecting the public safety. After the plea negotiations are finished, the next stages are simple, which leads me to a swift end of my speaking. We have preliminary hearing, which is where the judge then, for the first time, hears evidence to make a determination on if, via probable cause standard, this defendant can move forward to a jury trial. If the court finds that, yes, there is enough evidence to move forward to a jury trial, then we are then set for a jury trial based off of the court's calendar and time slots available. All right, I'm gonna stop reading. The rest of this is once the trial is done, whether you get it guilty or not guilty. If you get it guilty, then the defendant is able to go to the Court of Appeals and the Supreme Court and so on and so forth, and it keeps climbing higher. The reason why I did all of that and tried to answer a lot of the questions that were in the email that was sent to me, because a lot of it is based around how negotiations work and how a plea is made and how a case goes forward. That is the process. But what is extremely important is the constitutional right of the defense, that the defendant has to receive all of the discovery, all of the evidence, all of the police reports that we have. And in our private meetings, I can show you some actual case law, so I won't take too much more time tonight. But in that case law, it literally says, it doesn't matter if the DA doesn't have the reports. Doesn't matter if the DA doesn't have the videos or DVDs. If law enforcement has it, then the defense can argue for the case to be dismissed because the DA refused to give it over. I know that makes no sense. However, the law says it does. Because as the state of Kansas, when law enforcement has it and they present their case to this office, we are now one. So if they have it, by law, I have it. So what we oftentimes see are judges who give leniency because sometimes it takes a while to turn over information, especially when we're living in the time of data and digitalization and so on and so forth. But we have judges of late who are dismissing and threatening to dismiss cases because it's taking too long to get discovery over to the defense, which is why we have to change policies. Right now, there are some things that we are changing to make it so that our cases are not dismissed. Because once a judge dismisses a case, that's beyond the control of the DA. And I'm not able to bring a case back if it is dismissed with prejudice. However, before a case is filed, it is within my control. And so it's within my determination if we need more time to get that discovery, if we need more time to get all that information so that when we bring it to the court, it's not at risk of being dismissed. And that is, as I stated in my writing, just like the plea negotiations, it is a balance that we have to strike. And that balance is what is in the best interest of the safety of the community, while at the same time making sure that a case is not going to be dismissed. I think I've covered at least 8 of the 9 questions. Our data in 2025, we were approved to receive the funding to purchase a new software, which is called Carpel. And Carpel software is our data software that receives all of our cases, all of our information, all of our convictions, and all of our evidence documentation. We went live in June. That process is still undergoing to confirm accuracy because we are now having to remove the last 60 years, really the last 20, based off of what they used before Carpel and before this administration, and putting it into Carpel. And so hopefully by this time next year, the data will be solid and it will have been cross-checked. But at this point, we are in that process. Okay, now I will stand for questions, and if you have any, I will sit down.
Thank you, DA Dupree.
I'm sorry, Mr. Mayor. I did all of that. The affidavit. Okay, so what's in front of you? How does the case happen? So after the police department files or sends the information, usually it's the affidavit via email or through Carpel. It is that document. It comes to my office. And what you see on the front page is the affidavit. So that affidavit is prepared by the policing agency. And that policing agency sends that over to us. Once that is sent to us, we then have to take that and then we create that next page there, which is your warrant. We take that affidavit and that warrant and we take it over to the judge. Which judge is depending on whichever judge is available. Then my assistant district attorney reviews this affidavit as well as the information with the court. The court on that back page of that warrant, you will see, has to sign off for that case. So we can say we want to charge this person, but then we have to convince a judge that we have enough evidence to move forward, which oftentimes means sometimes when it comes over, we say, nope, not ready to go to the judge yet. Officer, detective, we need you to go and find more evidence. We need you to go and get us more documentation. We need you to go and get us, so that way when we present it to the judge can go ahead and agree and sign on. There has been times where the judge says, no, you don't have enough. I'm not signing it. So then we have to either decline to charge or just not charge at that moment. And then again, after the detectives or the agency go and get us what we need or whatever it is, then we can go and present it back to the court. Once that case is charged and the judge is signed off, we have the opportunity then to get the information. So that information is simply the same information that's on the warrant, but this is the information that goes into the court system. So this is the information that goes really into the public atmosphere. This arrest stuff and warrant stuff and affidavit, that's work, if you will, work privilege, which is why we can't talk about details of actual cases. You can't do that. So this stays with the court and stays with my office, but the information is something you can find there, okay? You have the opportunity either to request that warrant, or you can have what's called a notice to appear or a summons. I put an example of the summons in there, and again, where you see the judge has to sign off on these things. It is, as I spoke with your prosecutor the other night, the prosecutor's discretion to determine whether or not we're going to file a case based off of the evidence. However, the checks and balances of our system says the judge who wears the robe is the checkmate. And they can say yes or they can say no. Now, Mr. Mayor, forgive me, I am done.
Okay. Well, thank you, D.A. Dupree. We appreciate you coming out here this evening. And yes, you have been very good about coming out and giving us some time at least once a year. So we'll go ahead and open it up and see if there's any comments, questions from the council. We'll go ahead and start with you, Mr. Shannon. Do you have anything that you'd like to ask?
Nothing. It was very well described, and we appreciate you very, very much, both you and you look dapper. I'll tell you, it really looks good. Both of you being out here. Thank you so much. I have no further questions.
Thank you so much.
Mr. Kipp?
Thank you for coming out. Is that why you don't have a lot of data on crime up or down, and that is because of the new system? Is that
Yeah, it's because of the new system. Now, I can guesstimate, but I don't like guessing, especially for council. As things are transferring into the new system, once that is secure, then I can report out absolutely. What I can tell you is that from Bonner Springs, we've had about 400 cases that have come over in the last 2 years. And I was able to pull that to show what has been sent over. Now, I couldn't break that down in the new system on of that which we have either declined or we have taken back to the judge, and then the disposition of them based off of the software. But we do know that we've had around 400 cases in the last 2 years. And that's 24, 25, and I suppose half of 2026 at this point, or 3 months in.
do you know if it's a high or low number of charges that have been declined? Is that something that this seems very specific about something like that as far as how the process works? Has there been charges that have been declined more frequently than normal, or is there any shift in that, or it's?
No, there's no shift. The cases that are declined, either one is because we don't have the evidence that we need. And again, I can't get specifics, right? But just to reiterate the reasoning behind this is if a case is brought forth, let's say a murder case, and Bonner Springs does not see a lot of murders, and that's good, but it's an easy example. I don't want you to have more murders. So, but in a murder case, there is no statute of limitation, right? And so if the police department brings me a case and say, hey, we have this one witness and we have this suspect, but that's all we have, I have to believe that in front of the jury of Wyandotte County that this is enough evidence to get a conviction. I may in that situation say, hey, that's not enough. We need to get more. We're not going to move on it at that point, right? And so at that point, it's declined, but it may not be declined if we get more evidence.
Okay.
But there are other situations. I've had, and I'll give one that's not in Bonner Springs. I'll give just hypothetically speaking. A auntie yells at her child or her nephew and says, I'm going to whip your butt. That technically is a threat. It's a criminal threat. And it is a level 9 person felony. That case was sent to my office, hypothetically speaking, asked for me to file charges on this aunt who was taking care of somebody who's not her child, and they got into an argument and she says that. Here's the question, Mr. DA. Is it just and fair to put a felony, a person felony on this person for having an argument? Or is it better to get this person services and maybe some parenting and counseling help? That case, hypothetically, I declined and I referred them to get help. Was everybody happy with that? No, right? Because resources goes into it. I investigated that. I sent my detectives out and we wrote a report and we sent it to the office. But then when it got here, that discretion of the DA, that's where I said, no, we're not wasting our resources to go through this process, but we'll give our resources to help what is just and fair. So those are some of the examples where declines happen and everyone may not be happy about.
Okay, thank you for your time.
Indeed.
Ms. Gurley?
Thank you for coming out tonight, and I'd just like to invite you to come back more than once a year.
Just said I need not ask people what they think.
I know you're busy.
But thank you for the invite.
Taking time for us tonight.
Yes, ma'am.
Ms. Wood?
Thank you very much for coming out and giving us this pleasantly detailed, but not lengthy. I'd get so confused. Yeah, I will try never to commit a crime.
Thank you so much. I would hope you were successful on that.
I was going to say, it's only 8 o'clock, your time.
Anything else, Ms. Wood?
No.
Okay. Mr. McMahon?
That's why I sit beside her, because I feel safe. Between the mayor and Chris. Mr. Dupree, thank you for your service of 9 years. I've had a chance, I met you when you started stumping about 9 years ago, and you were over at the church across the street. We were both a little younger, and my hair wasn't quite as gray. And I think you got our attention, and I believe you got a lot of support. And obviously, you got that position. So it's not an easy one, especially if you take it from a perspective of being a person of faith and you're trying to make the best decision for individuals. And that really comes with a lot of challenges. And so with that, I do have a few questions, and I'll make it quick. And you know, you're not on a budget, right? I mean, you don't know how many cases are going to come before you. Is that fair to say?
No, it's fair to say I don't know how many cases are coming, but I do have a budget, and I do have to get approved, well, not approved with the budget, but go and request my funding every year. But no, I don't know how many cases come.
Does your budget determine how you make decisions? I suppose it wouldn't.
No, it doesn't. I just have to ask for more money when we get more cases. If we get more cases, we ask for more money.
And you go before who when you're needing additional funds?
To the unified government, which is where Bonner Springs, Edwardsville, and Kansas City, Kansas is represented. And by the statute, the county is represented by the UG.
Right, thank you. And do you feel like you're adequately staffed with having, you had mentioned maybe there's been some situations where things taken a little longer than what they should, and if that's the case, are you potentially, could you be understaffed, or could it be the case that you're particularly working on and that things need to move in a timely manner? So when we're discussing discovery and information?
Well, one, yes, I believe I'm adequately staffed now. During COVID, a lot of attorneys and a lot of DA's offices across the country dealt with it, but in the last 3 years, we have gotten all of our attorneys back up. But just for a point of clarification, when we're talking about the discovery, it's not a a DA's office slow process. So once the case is sent over, submitted to my office, it's important to note that what you have in front of you is normally the only thing that is submitted. With that, we try to make a determination on if we can reach that beyond a reasonable doubt standard based off of that affidavit that we have from the police, knowing that they're still possibly talking to other folks and still getting interviews or still having to get the recording, the dash cam and the body cam and all of that stuff. Well, the police still has all of that. We have the affidavit until the police sends all of that to us. The issue comes in is at the moment I charge the case, then that constitutional right and the statutory rights of the defendant, now they're charged, now the law says I have to give them all of that stuff. And so now the process is, how do we hurry up and get that information to us so that we can turn it over to the person that we've charged with the crime? That's where sometimes we have the issue with the court, because it takes on average about 3 months or so for Wyandotte County to get that information in. And so when we're operating with all of the agencies, we have to come up with something that says we have to be fair, so we need all this information. And so we have now put in place where we say, look, we're going to charge the case on good faith that within the next 7 to 14 days, you're going to get us everything else, right? And if you can't get all of that stuff that you have to us, then you need to tell us why and where it is, so that I then can tell the judge who has the authority to dismiss the case outright. So that's where sometimes we have the processing. It's not more of a processing in my office. It's getting it from all of the policing agencies. And I'm saying all, and I know I'm in Bonner Springs, but we deal with 8 different policing agencies in Wyandotte County. And so, and that doesn't include our federal partners. And so when we're creating this process, we have to think holistically, not what works for Bonner, what works for Edwardsville, what works for KUPD, what works for the community college, we have to think for the state and for the county and what works for the actual case, because the judge is a Wyandotte County judge, not a Bonner judge, not an Edwardsville judge, not a KCK judge, and they have the final say when it comes to dismissing cases potentially.
Yeah, so thank you for saying that. So if someone needs to remain incarcerated, and you're gathering, I take it when you say you're gathering information that would come from local law enforcement, right? When they arrest somebody, they file the report.
Yes.
I would imagine that they probably turn that over pretty quick, right? Whether it's Bonner or KCK, right? For the most part, generally speaking. 80% of the time, 90% of the time. You don't have to answer.
Thank you.
So as a council, I just want to ask you, what is it that you need so that if people should, and I appreciate leniency and contrition because I'm wired the same way, but sometimes, I think we instill too much trust in people, and then, things happen, right, that we all regret. There's nothing wrong with trying to make the best decisions and all that stuff. So I just feel like if there's anything that you need from a council, Bonner Springs in particular, to help provide resources to be able to, whatever it may be, to get the bad guy off the street and to keep him off the street, you let us know so we can do anything that we can, right? So, and I don't know what a number is, right? Because hey, it's Wyandotte County, right? Crime's probably a little higher here than it is in a lot of other counties in the state of Kansas.
We have a higher volume of crime.
There's a lot of density.
Exactly.
And I get it. So, but just anything we can do. And as I digress,
Yeah.
Thank you for what you're doing. Thoughts and prayers, right?
Yeah.
I get it. So, but just please let us know, because you hate to see someone get hurt
Yeah.
after knowing somebody probably, that we thought had a chance to get things turned around, they didn't.
Yeah.
So totally understand. Thank
Well,
you.
I appreciate that, and thank you for your prayers, and what you all are doing is good. I will tell you that it's important that your law enforcement agency and my office have a collaborative working relationship. And Chief Naff has my cell number, and I have his. Before COVID, I had lunch multiple times with all of his officers, and we just talked about making sure that now post-COVID, we do the same thing, because it's easier to have an understanding when you actually know people versus if all you have is a title. And it's real easy to be mad and upset at someone when you've never met them and all you have is their title. And I'm a pretty likable guy, and you're going to have to try real hard to look me in my eye and be mad at me. And so I think that is the main thing, is making sure that we have a collaborative working relationship, and understanding that I'm not the chief of police, and I won't try to be, but at the same time, the chief is not the DA, and he can't be. And so as long as we stay in each other's specific lane, I think we'll continue to have a good relationship, but we have to do what we have to do to keep the community safe.
Ms. Blanks?
Hi, thank you for being here. I do want to echo the sentiment that Councilwoman Gurley gave, that we would like to see you more. I've been on council since January 2024, and this is your first visit with us, so I do appreciate you being here. I will be transparent and say that I think tonight I went into the conversation of hoping to see real numbers of either statistics or crime going up and down, or when cases are being sent to you, are they going to trial? Are they being pled out? Are they being dismissed? Those are specific answers that I'm really interested in, and would love to invite you back in the next 3 to 6 months when you've had that software in place in time for us to see real numbers. I just feel like over here in Western Wyandotte County, one thing that our residents are constantly bringing up is just we feel like there's lack of services and lack of attention from the UG. So I would love to have further conversations of that. I do have some specific questions that I hope that you can at least try to answer that are not specific case related. In your presentation, you really focused on going over what the criteria is when considering and offering a plea agreement. So I just have a few follow-up questions from that. One being, are the crime victims and law enforcement officers notified before plea deals are given?
So, and I stated in that yes, the crime victims are notified, and in fact, within a couple weeks of the case being filed, we have that conversation with them. Concerning the officers, if the case is on an officer, let's say it is battery against a law enforcement officer, then yes, that officer is notified and we have conversation because we treat them as a victim. However, if an officer is simply the investigative officer and they took the report, no, we're not having a negotiation with the officer to make the determination on if we believe it's in the best interest to move forward with the plea offer. And so the answer is yes and no concerning that. But I do want to back up, because though this may be my first time seeing you here, we have sat and talked multiple times at events here in Bonner Springs. Maybe I have a forgetful face, and that's okay. But
I've
this
seen
is
you at some
this
events.
is
I'm talking
what I want to make
specifically
sure
at a
is
council
that
meeting
this
to go
is
over
not.
business. We've seen each
So
other
here's
at
what I
events.
want to
I'm
say
not
to
saying
you.
this is the
But
first
but
time
you
that
are.
we've-
But what I want to say is this: what I've indicated, and just as you're reading the email that your chief sent me on Saturday at 5 o'clock, this has been on your calendar for about 4 months. And the clerk has my email address, and all of you, if you have any questions that you have, you don't have to wait till I'm in front of a microphone. I think my whole statement about the chief, and I will say concerning you and all of you in this position, the best way to collaborate is to have those conversations. And so if you would like to have more in-depth conversation, I invite you to my office. I invite you to shoot me an email and we can have that type of conversation. But tonight is for presentation. And if you want to get into data and specifics more than what I've been able to give tonight, I would, in all due respect, ask that you don't ask me on Saturday, which is a day before I'm supposed to show up when it's been on the calendar for 4 months. I don't have a problem answering you, but I think we have to be very direct with where we are. And so there is clearly some things on your mind, and I'm all for answering them. But we need to do it in a way that gives everyone respect as well as time to give you the answer. Whether it's 3 to 6 months, or as I stated earlier, no later than when I'm here next year, when I have those solid numbers, we'll bring them. I promise you, we're not hiding anything.
So let me clarify. Yes, I've seen you at events, and we love when you come out, just like anybody from KCK or UG. We're constantly always being inclusive in that. But when it comes to specific business, this is the first opportunity that we've had. So again, I do appreciate you coming out here. As far as being welcomed into your office, well, I think that those closed doors conversations are necessary, right, to continue to build relationships and dig a little deeper. I think for me that it is important to have public conversations, because when speaking to residents or in the community groups, and there is always a concern about cases being brought from Bonner Springs to the DA's office. And when I'm speaking with residents who have gone through the process of filing police reports, have offered to be witnesses, specifically when it comes to violent crimes, they feel very underheard and underrepresented. And I think that's where my frustration comes. And when I'm following up with our police department, when I am bringing them specific cases that are brought to me, specifically by women in this community, and then I'm asking, where are we at on that? And then reports are being ran specifically in the last 3 years. And I'm seeing a lot of specific cases that are either just dismissed or pled down with individuals that have their background is of violent offenses. And I think that's, for me, frustrating. And I'm not saying you're hiding anything. This isn't supposed to be back and forth banter. I simply, just like you have those to answers to, my constituents or who I answer to, and when there seems to be a same topic of conversations, that's where that kind of starts to build with me of there just seems to be a miss. And I don't know if it's staffing issues. I don't know if it's because we're in Western Wyandotte County that so.
Ms. Blanks, I got to reply to that. I disagree, and I reject the premise that it's because you're in Western Wyandotte County. I live right down the road, and many of the people that are in my office and who are employed there and who happen to work in the DA's office live in your city, okay? So it's not because of that, and I've done a heck of a job trying to make sure you know that and your people feel that. Moreover, whatever run or data that you ran for the last 3 years, it wasn't in my office. So having said that, I think it's unfair for you to state that there's some big push of domestic violence cases or women's cases is what she stated, that are saying that they're being dismissed or that we haven't moved forward to and we're playing them down. Wherever you're getting that information, I just stated my office hasn't been able to run it. And so clearly you're getting something from not the source of whose statutory obligation it is to deal with it. And so what I'm saying is, let's go off of the facts when we have them, and hearing tonight what you want. And again, Saturday is when I got these questions, and might I add in those questions, it had nothing to do with any of the stuff that you just stated concerning specifically women. If you want certain questions answered, I will answer them, but you need to ask them so I can have the amount of time to answer them.
I think I'm just a little taken back that you opened up the floor for questions and that my questions are very generic about how your office runs. And I just have asked one question and it's just immediately shut down and defensive. And that's not the way that I saw this conversation going. Because why open the floor for questions?
So are you asking me a question?
Well,
all
yeah,
the way
I
up
just,
until
I'd only
Ms.
technically got to
Blanks,
ask you
Ms. Blanks,
one question
Ms.
before
Blanks.
you shut down the conversation.
I'm not shutting down your conversation. I've answered all the way up until here. Nobody has had what you can ask me whatever questions that you want to ask and I'll answer them, but you're right, pardon me. You're asking questions, but then you're launching allegations. And so I'm saying, if you want to have a conversation, we can have a conversation, ask the question, but don't lodge allegations, and we can have conversations about that. And so if you have any more questions that I can answer, if it's concerning data, tonight I've told you I can't answer the specific data for you. And like I stated over here, I could guess if you want me to guess, but clearly that's not what you want me to do. And so we can move forward and have those conversations later.
I would like to invite you back, please, for a constructive conversation to see actual data and numbers, which is, I think, what we're wanting to see as a council, to see where our numbers are in Bonner Springs in reflection to Wyandotte County, and how the DA's office correlates into whether charges are being pled out. Are they violent offenders that are being pled out to misdemeanors? I think I'm just trying to have a constructive conversation of real numbers. And I think I was just surprised to not see any of like data tonight. So maybe that was my misunderstanding of assuming that that's what tonight was going to be. So I do have other questions. Like I said, if you could come back in 3 to 6 months, I will make sure to get those to you ahead of time, even though I do think a lot of them are just very across the board of how your office operates. So I digress because I don't want to go back and forth with you. That's not my intention. Again, my intention is to get answers for our residents. And also when I'm speaking with our police department and I'm holding them accountable, and I know that they only, like you stated, they only go so far in the process before it goes into your roadway. And so I think I'm just there seems to be a disconnect there that I would just love to further and better that relationship. So thank you for being here.
Ms. Long?
Thank you for being here. I have a question specifically around, you were talking about collaboration and collaboration with the police department. You have the chief's number, he has yours. But then you keep bringing up that there was something Saturday night that was sent when this has been on the agenda for 4 months. And I'm curious if there was no collaboration beforehand to say, hey, chief, what's on your mind as I come to this meeting? I'm just curious about that side of things too. So, and also I want to echo the statements that Ms. Blanks made. There should have been some more data, some more things that we could actually look into, that we could actually see for our community, other than here's what an affidavit looks like. This is a process. That was very helpful, and there should be more information. We would love to have you back out. I also didn't appreciate how dismissive you were of Ms. Blanks, so just letting you know that. So next time maybe we can have more collaborative construction. We could all go to your office, but we all can't go at the same time. So this is our opportunity to have a constructive conversation about what's going on in the community. Again, secretive behind closed doors. How many of us can go before it's an open meeting? If we've all got the same questions, we kind of need them to be answered here. So that's all I have to say. Thanks.
Mr. Reeves?
Yeah, thank you, Mr. Dupree, for being here. I appreciate you being here. Thank you.
Thank you. And I'm sorry, was Ms. Long, was that a question at the beginning of that besides the...
about the collaboration, if you want to answer it, fine.
I was waiting for my opportunity. I didn't want to be accused of going back and forth.
Well, you could have just cut me off the way you did Ms. Blanks. I don't know.
Okay.
This is the worst I have ever been treated in Bonner Springs in all of my years coming.
Everyone.
So I want that to be known. And I've been coming since I was elected. I've never been treated with such a disrespect. So I want that to be heard. There's a way to have a conversation, and that is not it, and it's not okay. The chief has my cell number, and we have talked. And since the chief has been here as your chief of police, he has come to every one of the presentations that I've had. And not one time has he indicated to me that my presentations have not been up to par, and no time has he indicated that he would like for me to speak on this or speak on that. In fact, we had a conversation last week concerning what we're doing in our offices. And so, no, the chief did not give me the, hey, these are the things you should say. Why? Because we have a constant communication with our work. This is for you all who I don't have constant communication with, and trying to give it to you in a way that ethically and legally I can give it to you, because I can't go into all of the facts and the evidence of cases. I can't tell you that when the case was filed, we had 3 witnesses, but 2 of them now are dead, and so now I have to plea a case out. And so I can't tell you those facts, but this case now is not going to trial because we don't have those things. There are certain things I can't ethically and legally tell you specific to cases. And so, no, the chief did not give me a rundown on what he wants me to say to you. He sent me an email on Saturday saying that these are some of the questions that I received from counsel. Forgive the late notice, but I wanted to make sure you got them. So that's why I wrote out a script to try to answer what the chief sent, because he believed this is what you wanted to know. So there is no issue or breakdown between the chief and I. This is simply to make sure that you all are aware of what's going on and how things operate. And yes, as long as next time when I come, you have some coffee and I have a heads up that I'm going to be speaking longer than 10 minutes, I will absolutely come back, Ms. Long. So thank you for your question, and thank you.
I do have a couple more for you.
Please, Mr. Mayor.
Hopefully not as bad. We won't attack you too much. I understand there is a new policy, I guess, that's been established about a 48-hour window for information to make it from our police department down to your office. Is that accurate?
That was accurate. That was changed late last week, and I emailed your chief this morning of that. The issue, as I stated, was judges ultimately threatening to dismiss and has dismissed because we didn't have all of the evidence.
I was going to say that window was starting at the time you actually filed the case.
Exactly.
Correct? Now, the decision to file the case, is that made in coordination with our police department, or does the office, your office, make that decision all on its own?
Yeah.
Even if they believe there's more investigative work that still needs to be done.
That's the part right there. So I would say the ultimate decision is ours. We're the only ones by statute that determines if a case is going to be charged. That's our sole responsibility. However, if the police department doesn't do the investigation, we have nothing to go off of, right? And so with that, as stated in my previous comments, there may be times where they bring us something and we say, hey, this is not enough to take to the judge. We need you to go back and get some more. So that back and forth is to determine if we can present that information to the judge.
Okay, the question then becomes is if they are still in the process of doing and trying to gather additional investigative data, will you hold off on filing those charges, or will you go ahead and file and then that starts that little bit of that window?
Yes, so we start the charge. So let me give just a little bit of context because I know what you're talking about. Mm-hmm. So a week and a half ago, we kind of ran into a brick wall concerning this with the court. And the court says, look, bottom line is, I don't care who has this information. This case is about to be thrown out. And so we then said, look, excuse me, all of the agencies, if you want to file the charges, we need this information when you bring it, right? Because now we have to answer to the court. They used to give us more time and be lenient and say, no, we understand, and so on and so on, but right now this is where it is. So now we're at a place where, having talked to multiple agencies, they said, look, we get it, and we don't want the judge dismissing our hard investigative cases, but it's hard to get all of that information within that 48 hours. And so what we've done is saying, okay, fine, that 48 hours, we're still filing those charges, but the goal is now between 7 to 14 days, do whatever you got to do, but get the rest of that information to us. So to answer your question, yes, we're still moving forward with those charges, but we're pushing, saying we can't delay because we don't have a valid excuse in front of the court at this point.
But you've lengthened the window that they have
Yes.
to get that evidentiary evidence to you.
Yes.
Okay, good. And then another one, so I guess there is, I don't know if that is your office or the courts themselves that are wanting to push domestic violence cases back to the municipal court here in Bonner. Is that true? From what I
Say that
understand?
again.
I understand that the domestic violence cases,
Yeah.
there's a push to have those come back to our municipal court here in Bonner Springs. Is that true? Or?
So let me give just a little bit of history because we were not aware that they were not coming to Bonner Springs. And I spoke to your prosecutor Friday about this because I was questioned by a judge who said, why are we receiving Bonner Springs misdemeanor domestic violence cases? And I said, I don't know, let me talk to someone. Well, it's important to note that historically, all of the cities in Wyandotte County deal with their own misdemeanor cases. Wyandotte DA's office is known as the felony office because the felonies are the state statutes and it's a felony. So, and we have plenty of them. And so about 18 months ago, we start receiving more domestic violence misdemeanor cases out of Bonner Springs. And we had judges who said, hey, we're busy, tell Bonner Springs to continue to handle their cases, and would not sign on the dotted line up there on some of the cases. And we made that known, but what we end up doing is saying, okay, look, if you got domestic violence cases where it is bad, try to send them to us, and if the judge agrees on signing them, we'll take them. We have never turned down any of your domestic violence misdemeanor cases, despite historically not receiving them, but we were not in conversation about this transition, hence going back to that collaborative aspect of things. And so without being in conversation, and I talked to your prosecutor and he said, you know what? Yes, I should have had a conversation with you about that shift. And because I didn't have that conversation, I wasn't able to have a conversation with our district court judges about this shift. And so these changes were happening and we didn't know that it was happening. But in spite of that, we never said no to these domestic violence cases. Now, I'll tell you one of the questions that the judge did ask me, and Mr. Mayor, I'll bring it back to you, is why is it that Bonner Springs is not handling your domestic violence cases?
And that I couldn't answer you. So, but yes, that is something we need to definitely, if that needs to come back to our court system, then we need to handle it. But we need to probably have staff work with your office to make the best determination on how we coordinate getting that moved back here for those misdemeanor, domestic violence cases then. But
Absolutely.
I appreciate that better perspective of overall how that all occurred. So thank you.
Look, what we can do, we will do, but I will not pretend as though it's not an extra caseload on us. And we can figure that out if need be, and if that's the best way moving forward. It's just about sitting down at the table and figuring out, is it going to be all of your domestic violence misdemeanor cases? Is it going to be more than your domestic violence misdemeanor cases? And my understanding was that via our conversation Friday was that it's the no probation that you have to supervise these individuals if and when a conviction occurs. And so I think that goes into, okay, let's have a more in-depth conversation on if this is the best route versus just, no, send everything there and then we kind of just roll. Because I don't have answers for judges, and I dare not speak for you all, and which is why then I pick up phones.
Well, I appreciate that information. I think our staff will need to probably work with our judicial system and then work with your office to understand the best way to move forward in handling those, and especially in our courts. So thank you
Absolutely.
very much. Is there any other additional questions? Anyone? Seeing none, we've kept you long enough here. I'm sure you are ready to move on, DA Dupree. I appreciate you
Well,
coming
thank you
out.
all for this opportunity. Thank you for allowing me to speak. Thank you to Chief Knapp for all of the wonderful communications that we have. And if you have any more questions, please reach out. I will say that concerning the misdemeanor deals, Chief Knapp, because it's his agency who sends those to me, did reach out and say, hey, we're sending you this stuff. And so I want to just point of clarification, there was communication from your chief saying, hey, we're sending you this. But the background stuff, that was not the conversation on how it got here, why, and what our thoughts were. So, but again, thank all of you, and I look forward to seeing you within 3 to 6 months, apparently. So you guys have a great one and be
Appreciate
blessed.
it, DA Dupree. Okay, moving on. We will go to the consent agenda. If a council member has a simple question about an item, they can ask before the mayor calls for a vote on the consent agenda. Is there any item that needs to be pulled by staff? Yes.
Before we move on to the consent agenda, we have someone who's.
Well, I was going to say, I figured we'd just go ahead and get the consent agenda, and then we can move that item up. Does staff have anything to pull from the consent agenda? Is there anyone from the audience that wishes to pull anything? Council? Seeing none, I would go ahead and entertain a motion.
Mr. Mayor, I make a motion to approve the consent agenda as written.
Second.
A motion by Mr. Reeves, a second by Mr. Shannon. Go ahead and call the vote, please.
Gurley,
Yes.
Gibb,
Yes.
Reeves,
Yes.
Shannon,
Yes.
Wood,
Yes.
Long,
Yes.
McMahon,
Yes.
Blanks,
Yes.
motion passes.
Okay, on to new business. We are actually going to address item number 9 first. It is a resolution for legal services agreement related to the AFFF product liability litigation. And the reason we're doing that is because we do have a particular firm, I know I'll probably pronounce this wrong, but Stagg Louisa LLC, are going to be coming in through Zoom. They're already connected, and they've been waiting for about 25 minutes, so we're going to move right on to it.
Mayor, if I may have a moment, I'm going to tie in Stagg Louisa from New Orleans. I should have him up on the screen here.
Okay, appreciate that.
My name's Shane Lilich. I'm with Perry and Trent Law Office. We are your local law firm right here in downtown Bonner Springs. We are working with several public water providers throughout Kansas to work with them to test their water to see if they're eligible to make a claim in a federal class action lawsuit that's pending in the Federal District Court of South Carolina. We are working with Stagg Louisa out of New Orleans Mike Stagg is joining us remotely this evening to answer any questions that you might have. Essentially, what needs to happen to determine if the city of Bonner Springs is eligible to make a claim is there needs to be a testing done of the source water, that is before filtration, to determine if there is a claim eligible amount of PFAS in the water. If it is determined that there is, we will assist the city with working with Stagg Louisa to make that claim. Stagg Louisa would be responsible for any litigation related to the claim. I recently met with Amber Vogan to answer some of her preliminary questions about this. Certainly am honored and appreciate the opportunity to address the City Council tonight and answer any specific questions that you might have. But really, what this boils down to is that there are settlement funds available from 3M and DuPont related to these PFAS that have infiltrated water throughout the United States. These chemicals are referred to as forever chemicals, and when consumed, they can cause a variety of different ailments. These settlement funds are targeted towards remediation. If it is determined that the city of Bonner Springs is eligible to make a claim, the funds that would be awarded to the city of Bonner Springs can be used as the city deems fit, to add additional filtration as may be needed, or to otherwise remediate the concern. The amount of claim that would be awarded is a function of the level of presence of the PFAS that are determined in the water, if there are PFAS, as well as the flow rate. The flow rate is essentially the amount of water that Bonner Springs provides to the public, but it's a combination of those two factors that would determine the amount of settlement that the city of Bonner Springs may be eligible for. We have a deadline approaching of March the 31st. If the city of Bonner Springs tests before that deadline, the expenses associated with the testing would be covered from the settlement fund. And again, Mike Stagg is joining remotely. I think the city council can see him on the screen now. Hopefully, Mike, you're able to hear me?
Yes, I hear you great.
Okay. So we would be more than happy to answer any questions that the city might have about this. I have provided Amber a proposed representation agreement. Are there any questions?
Well, I appreciate that, Mr. Lilich. And I would open it up to, is there any resident that wishes to speak on this matter at all? Seeing none, I would go ahead and entertain a motion by council.
Mr. Mayor, I make a motion to adopt a resolution authorizing the city manager to execute the legal services agreement with Stagg Louisa. Sorry, did I get that close?
Yes,
LLC.
yes, Ms. Gurley.
And Perry and Trent LLC for services related to action or claims in the aqueous film forming foams product liability litigation.
Second.
So we have a motion by Ms. Gurley and a second by Mr. Shannon. And we'll go ahead and start with you, Mr. Reeves, for any comments, questions, concerns?
I don't have any yet.
Okay. Ms. Long?
I don't have any, thank you.
Ms. Blanks?
Thanks for your time, Shane. No questions.
Mr. McMahon?
There's a lot to process here. What triggered this? Real simple. What flagged us? And just
Let him answer.
no. Right. The product that may be in the water or something like that. This is interesting.
Yeah, this, these chemicals were used in lots of different products. The product that's at issue here is firefighting foam. It's used to put out what I call hot fires, fuel fires. The military used it heavily. Airports were mandated by the FAA to use it. They started using it in the 1940s, and so it's been used for many decades. The issue with the firefighting foam is it has these PFAS chemicals, PFAS chemicals that, as Shane mentioned, are forever chemicals. They're synthetic chemicals that tend to resist biodegradation, meaning they don't break down in the environment, and they persist. And manufacturers knew about this and knew that they had potential health concerns, but sold them anyway. So it's a product liability case, and it's a cost recovery action because water systems will have to incur costs because these chemicals are being added by the EPA to the Clean Drinking Water Act. So, like other contaminants that can be found in drinking water, like lead or mercury or all the other things that end up on the Clean Drinking Water list, water systems are going to have to test and report and potentially remediate if they exceed a certain level. And water systems didn't cause this problem. It was the manufacturers of the chemicals that created these chemicals. They have specific signatures. You can tell who made these chemicals. And so the action is to make them responsible and pay water systems money. At this point in time, you are a qualifying water system, meaning that you're on a list that says you are qualified to make a claim. There's also, because it's an opt-out class action, if you did nothing, by default, you're in the settlement, meaning you settle your claims, release these defendants, and in exchange for that, you should get an allocation of money. The only question is, how much will you get? And so that's what we help you do. There's a process that we have to undergo to help get your money that you're owed for releasing 3M and DuPont in accordance with the settlement agreement that the judge approved. So that's where this all comes from. I hope I answered your question.
Yeah, you did. I'm concerned about the side effects of any kind of consumption of whatever this product that's in the water. So the city could be rewarded X amount of dollars, but it's the constituents that are the ones that's growing a third eyeball. No pun intended, right? I'm just being real. So that I always find that interesting. So anyway, we haven't done any testing as of yet. Is that fair to say? Here in Bonner?
I think Bonner does testing,
Right.
but it's in-product water testing that's done through the Kansas Department of Health and Environment. We will be testing at the source, should the council approve us to go forward. That source water is the basis to determine eligibility for the claim. And go ahead, Mike.
What that means is that the water that's going to customers, it can be perfectly safe and have none of these chemicals in it because your system may be already taking these chemicals out. We go and we look at the source to see whether there's any detectable amounts, even if it's very, very small amount. But the way the settlement is written, I say settlement, I'm really talking about a settlement agreement in terms of the agreement that the judge approved under which these funds are paid. You get paid not based on whether the water at the end has PFAS, but you get paid on whether you're dealing with any at the beginning. And really, the levels that we're talking about are very, very small levels, very low levels. And the reason is that they're trying to get the lifetime dose exposure down. So it's not like you drink one cup of water and you're gonna have an issue. It's really about a lifetime of being exposed to these chemicals. And a lot of the regulatory action that's taken place so far has actually shown that our blood levels in our bodies, that we all have in our bodies, are going down. So these efforts are working, that's the good news. And so, there's less and less of this chemical that's in our environment and also in our bodies. So that is the good news, to take away. And this is part of that effort, is adding this to the Clean Drinking Water Act. So, there's less and less exposure to it.
Thank you.
Ms. Wood?
No, but thank you very much for coming and speaking to us.
Ms. Gurley?
I do have a few questions. I work in manufacturing, and one of the things we've been focused on for the last about 10 years is eliminating PFAS in our products, partially due to legislation, partially due to the betterment for humanity. So if I understand correctly, the class action suit has already been put in motion, settlement has already been determined?
That's correct.
And is there a finite pool of money that it's in our best interest to act on this quickly in order to get our piece of that pie?
Yes, that's correct. It's 3M put up $12.5 billion. DuPont put up $1.185 billion. And so those are those funds that we're applying for. If you don't apply, then that money will either go to other water systems or it'll go back to 3M or DuPont. So it's really important that you do apply to get your slice of the pie, as you said.
Okay, perfect. Is there any long-term action required on our part? We test however many times are required to qualify. We qualify for the settlement, we get money done?
The process is we meet with the water people, we do a couple of tests early on, we get some data that they already have in their possession to keep for regulatory purposes, and we make the claim. You're not required under the settlement to continue testing, however, the regulators will, are adding this to clean drinking water testing that you already do, and so these chemicals will become part of the routine water testing.
Okay, perfect. And there's no financial risk to the city to undertake this process?
No, we make it very easy. We do it all contingent. So if we don't recover anything, you don't owe us anything. Okay. And that includes any costs we might expend for the testing. We're going to get that reimbursed out of this settlement fund.
Thank you.
No questions.
No questions, thank you.
I think you may have answered the question. That's what I wanted to make sure about how the product would have potentially got into our water system. It's nothing that we've done at the water system level. It would be coming from the source at the wells. So I just want to make sure our system is functioning accurately. So, and I think, I don't know if to answer your question, it was in the Mr. McMahon. It talks that we have done some testing, but this allows testing at a much smaller microscopic level. So in case there's we haven't found anything at this point in time, which is good, but we would hope that even at the smaller levels, it would, the best thing to do is not have to worry about the class action suit and have to be involved in it. So if there's no other comments or questions from anyone, I would go ahead and have the clerk go ahead and record the vote.
Voting to adopt a resolution authorizing the city manager to execute the legal services agreement with Stagliuzza LLC and Perry and Trent LLC for services related to action or claims in the aqueous film forming foams product liability litigation. Blanks?
Yes.
Long?
Yes.
Shannon?
Yes.
Kip?
Yes.
Gurley?
Yes.
Reeves?
Yes.
Wood?
Yes.
McMahon?
Yes.
Motion passes.
Thank you, Mr. Saggs and Mr. Lilich. Appreciate that.
Thank you.
Presentation. And we will now go back to item number 1, which is the Bonner Springs City Planning 0224, a comprehensive plan amendment for future land use map amendment. This item and the following item were both, did that first one have the public hearing?
It did, sir, but it was 2 years ago. 24 was
But
when we
it
had
did
the
have a public hearing.
Yes,
Okay.
it did.
So the first item, we'll go ahead and cover it. It'll be as a separate item from item number 2. So there will be, since it had a public hearing at the Planning Commission level. There will not be any additional comments taken from the public. So at that, I will go ahead and turn it over to staff for presentation.
Good evening, Mr. Mayor, Council. Mark Lee, Community Development Director. The first item we're looking at this evening is a future land use amendment to the comprehensive plan for the property of 720 North 118th Street. The property at 720 North 118th Street has gone through several planning processes over the past several years, but no development has ever occurred upon the property. The future land use map indicated in this area previously was reserved for mixed use, which was residential and commercial, but was changed in 2023 to industrial and subsequently rezoned as such. The parcel is currently zoned as LI, light industrial, and was included within the most recent development proposed by Van Trust Real Estate, and previously was within the Bonners Crossing development. The current request is to amend the future land use map